The Honourable Member Andrew Little.
Thank you, Mr Chairman. Pleasure again to just to make some comments on Part 3 of the Inquiries Bill. And I just want to draw attention to just some clauses in this part because I think the provisions of this part are really the meat of this piece of legislation, and they could stand us in very good stead in what could be some very important inquiries, some of which have already been alluded to already this evening. I note in Clause 10 the principles there that any inquiry must abide by in conducting itself, and I was interested to note the words that the members must act independently, impartially and fairly. And the last time we heard those words actually was in a speech by Richard Nixon after he had just sacked John Ehrlichman and John Dean, his White House counsel, and to set up an inquiry into the conduct of certain matters to do with Watergate. But there we go. That was an inquiry that had all sorts of ramifications, not the least of which for Richard Nixon himself. Mr Chairman, I want to draw attention to Clause 11, which limits the scope of an inquiry. Very important that inquiries of the nature contemplated by this bill, as indeed with commissions of inquiry, are about getting to the facts of the matter so that there can be an improved understanding about the cause of an event or events, so that public confidence can be restored if indeed public confidence has been shaken as a result of an event or an incident. And so it is very clear, the bill makes it very clear, that an inquiry convened under the aegis of this legislation is not to determine civil, criminal or disciplinary liability. So that people who are participating in it, certainly giving evidence in it, cannot be held to be criminally or civilly liable or to face any particular disciplinary action. It does not mean, of course, that recommendations cannot be made, that further action be taken by other bodies, but it is very important to note that the inquiry itself cannot have a civil, criminal or other disciplinary effect. The next clause I want to draw attention to is Clause 14, and that is the natural justice clause. The original Clause 17 in the bill as reported back from the Select Committee, reported back from the Select Committee. The original bill as drafted had Clause 17, that's gone. The natural justice provisions appear in subsection 2 of Clause 14 and also subsection 4. And that's very important too, and that is simply to ensure that if there is any adverse finding likely to come out of an inquiry, then those against whom those adverse findings may be made will have an opportunity to respond or to comment before those are published. Clause 15 is very important, and this is about whether or not an inquiry during its conduct can close itself to the public or suppress evidence. And I think Trevor Mallard's supplementary order paper number 332 is apposite. It starts with a presumption that inquiry hearings will be open, but it provides a protection there if it's felt that interests of others, of individuals, may be compromised if it goes public. I note in that regard when an inquiry is considering whether or not to suppress information or suppress its hearing or keep its hearing private, one of the factors it must consider is whether or not it would interfere with the administration of justice, including any person's right to a fair trial. I draw attention to all those matters, Mr Chairman, because the government has the opportunity, in fact I actually think it now has a duty, certainly after tonight's broadcast on TV3, which concluded only 15 minutes ago, about the latest revelations on Tana Pora and on Malcolm Rewa, to open an inquiry, a full-going inquiry. It can do it, and under the principles of this bill, when it is enacted, it will be able to do it without compromising any criminal procedure or indeed civil or other disciplinary procedure. But the case for inquiring into that matter is now compelling, and it must happen. Now, I want to conclude by, and I'm sure there'll be plenty of comment on that in the days to follow, because the revelation tonight is an absolute bombshell that the police knew the identity of Malcolm Rewa as a rapist after the first rape in what was a series over 7 years. The police knew it. It is time for an inquiry, and this government is derelict in its duty if it does not have one. I want to make one final point, and that's about legal assistance. I note that the legal assistance provisions allow what is described as the relevant department to grant legal assistance. That is not the Ministry of Justice. It is either the Department of Internal Affairs or any other department that is administering the inquiry. And that gives great scope, Mr Chairman, for proper legal assistance.
The question is that Part 2 stand part, Part 3 stand part, but before we do that, we have some Minister's amendments, which are set out on SOP number 330. All those in favour, please say aye. The contrary, no. The ayes have it. The question now is that the Honourable Trevor Mallard's transcript amendment to clause 15 be agreed to. All those in favour, please say aye. The contrary, no. The ayes have it. The question now is that Part 3 as amended stand part. All those in favour, please say aye. Contrary, no. The ayes have it. The question now is that Part 4, debate on clauses 29 to 40 and Schedules 1 and 2 stand part. All those in favour, please say...
Trevor, are we taking any calls on
Well,
this?
before we do that, we've got the Minister's amendments, where the Minister's amendments set out on SOP number 330 be agreed to. All those in favour, please say aye. Aye. Contrary, no. The ayes have it. The question now is that Part 4 as amended stand part. All those in favour, please say aye. Aye. Contrary, no. The ayes have it. The question now is that the schedule stand part, and we have a motion here that the Minister's amendment set out on SOP number 330 be agreed to. All those in favour, please say aye. Aye. Contrary, no. The question now is that Part 1 stand part. Schedule 1 stand part.
No,
all those in favour, please say aye.
Aye.
Contrary, no. The ayes have it. The question now is that Schedule 2 stand part. We have the Minister's amendments set out on SOP number 330. All those in favour, please say aye. Aye. The contrary, no. The ayes have it. The question now is that Schedule 2 stand part. All those in favour, please say aye. Aye. The contrary, no. The ayes have it. The question now is that clauses 1 and 2 stand part. The question is that clause 1 stand part.
Mr Chairman.
I call the Honourable Ruth Dyson.
Oh, sorry, Mr Chairman, can I just seek clarification? Are we doing 1 and 2 together, or are we doing them separately?
Well, you can do both together.
Mr Chairman, I'm happy to seek leave.
Votes.
I'm happy to seek leave that clauses 1 and 2 be taken as one debate, but with 2 separate votes.
Is there any objection to that course of action being taken? There is none.
Oh, that was pretty speedy progress in resolution. I'd recommend that to other members of the House who tried putting procedural motions before the House earlier this evening. Mr Chairman, ordinarily